Hello, welcome viewers to yet another lecture in the series of Media Ethics and Laws. Today we shall discuss Cyber Laws, which is Unit 11 of your course MJM025 if you are a student at IGNOU pursuing your MAJMC or PGJMC. However, if you have tuned into this video as a layperson, I assure you, you will not be disappointed with what we discuss today. Cyber laws is important for us as much as a citizen as a student of media. The structure of this unit that we shall discuss today, which is Unit 11 of your course, is we shall talk about the concept of cyberspace, characteristics, issues emerging from cyberspace and the needs for regulations, international and national laws about cyberspace, that is known as the cyber laws, Information Technology Act of 2000, which is the Indian cyber law, in which we shall discuss the electronic signature and electronic records, regulations, certifying authorities, cyber appellate tribunal, and even the intermediaries. We shall wind up with a discussion on cyber crimes, where we'll talk of the types of crimes, cyber crimes, some of the cases in the courts, how they dealt with them. With this, if you feel it is an interesting topic, you would like to know about it further, let's introduce you the concept. In the era of the rapid use of information, communication technology networks, devices, services worldwide, the cyberspace has emerged as a new medium of communication. According to the International Telecommunication Union, international internet bandwidth is growing rapidly worldwide, and India is amongst the front runners, a nation in the world which is actually acquiring new internet users by the minute. The new virtual space has thus given rise to many social and national issues and has posed new challenges to deal with technology-driven cyber crimes, and to protect persons' privacy and intellectual rights are amongst the major challenges and needs of the hour. With this, we come to what is cyber law. What is cyberspace? Why do we need laws? Of course, you would say, okay, we understand the world is shrinking, it's a global village, global, local, everybody is connected, and therefore we do become privy to certain unintended or even lawless activities. But what do we mean by cyber laws? Friends, as the name suggests, cyber laws refer to the legal regulations governing the use of the internet and digital technologies. These laws address issues related to online security, privacy, intellectual property rights, and much more. So with this shrinking world, the virtual one which is at your fingertips with just the click of a button or a key, there are laws which govern even this world. But as we all know, these are emerging areas, so even the laws are emerging. The concept of cyberspace is, it is a virtual environment where communication over computer networks occurs. It is the notional environment in which digital communication takes place. So when we talk of tangible, intangible assets, this is not tangible. You can't probably hold it, carry it, touch it, but it happens. So therefore the term cyberspace, virtual, notional environment comes in. Characteristics of cyberspace: it has a global reach. Cyberspace, of course, transcends the geographical boundaries. Users can act anonymously. Information is accessible to anyone with the internet access, and it is difficult to regulate all these activities due to the vast and decentralized nature of this information and communication flow. Therefore, friends, the features like global reach, accessibility, anonymity, and the lack of particular fixed regulations makes this space a very complex milieu to work on. Issues that emerge from the cyberspace and therefore give us the need for regulations are issues like cyber crimes, privacy concerns, intellectual property. Need for regulations thus emerge, as in there are crimes like hacking, fraud, identity thefts, or the misuse of personal data, privacy and unauthorized use of the content of the users, their data, their information. Therefore, to protect the users and maintain order in the digital space, we do need digital regulations. Now, there are many national and international cyber laws which have now started coming into being, as and when the needs are arising, they are going through their amendments also. Cyber laws vary across countries, but they also share some common principles. There are international laws and treaties, there are conventions on cyber crimes, there are certain acts which the countries which partner on these treaties they sign. There are also national laws. Each country has its own regulations, like the IT Act in India. Other countries would have their own national laws. But the need remains of global treaties because cyberspace is not limited by geographical areas. Because the nature of the space is global, therefore you also need laws which are global or international in nature. Now, some of the major international laws, you will read about them in detail in your unit, in your study material. There is a Budapest Convention. This was the first international treaty on cyber crime, and many nations did sign it. Then there is United Nations, which efforts are made to create global frameworks for cyber security. So UN keeps on coming up with these efforts, these treaties where it involves different countries from all the parts of the world, and these things do come up. But the international conventions like the Budapest Convention are certain welcome steps towards this emerging area. So friends, apart from the international treaties and conventions that we go through and encouraged by all of them, we have also come up with a very robust national law in India, the Information Technology Act of 2000. This is the primary law in India governing the cyberspace. But, as is the beauty of our constitution, with the evolving social needs, with the coming in of new requirements of the society, we do have the provision of amendments. Therefore, this act, though it was enacted in 2000, has gone through various and many significant amendments. Various amendments have been made to address the emerging cyber threats, the emerging requirements of the cyberspace in this Indian law, which is the IT Act of 2000. Information Technology Act of 2000 and its amendments in India, if you would like to know about it. The IT Act provides the legal framework for electronic governance in India, key provisions being those for offences, penalties, and procedures for investigations. So broadly, this is the Information Technology Act. It provides for the difference between electronic signature and electronic records. What does it mean? As per this act, a digital equivalent of a handwritten signature is known as an electronic signature, and legal recognitions of digital documents in this act, which are known as electronic records. Regulations of the certifying authorities are specified by this act. It talks of intermediaries, controllers, authorities. Certifying authorities are the entities authorized to issue digital certificates. Their role is to ensure the authenticity of the electronic transactions. Somebody should not just say there is a work in paper in a hard copy and just brings it to a softer version and claims a right to it. So all this is to be regulated and looked on by the CAs, which is the certifying authority. So not the charter accountant. In the cyber law context, CA means the certifying authority or the regulatory authority for the digital content. Now, powers of the controller. When we talk of the CAs, what are the powers of the controller? Granting licenses to certifying authorities is the power of the controller, monitoring and supervising the CAs, and also specifying the standards. In detail, the controller has the power to issue licenses to CAs for operating as authorized entities in issuing digital signatures. The controller is responsible for monitoring the activities of the licensed CAs to ensure compliance with the provisions of the IT Act and the related rules. And the controller also has the authority to set and enforce standards for the digital signature, including formats, security procedures, and the practices to be followed by the CAs, which is the certifying authorities. Now, there are more powers that the controller has: certification, regulation, powers to investigate, and even the powers to issue directives. Also, ensuring credibility, maintenance of the repository, enforcing powers, and dispute resolutions. Let me in one line detail out these powers of the controller. The controller can certify public keys and maintain a repository for them. It also includes certifying, revoking, or suspending digital signatures issued by the CAs. The controller has the authority to investigate any controversies of the provisions of the IT Act or rules, including unauthorized issuance or use of digital signatures, and Also to issue directions or orders to CAs or subscribers regarding the proper use of digital signatures and related activities. Other things that the controller does is the controller is also responsible for ensuring the confidentiality of the information provided by subscribers during the registration process with the CA. The controller maintains a database of all the licensed CAs and their activities. This repository is crucial for public access and to verify the validity of the digital signatures. The controller has the power to impose penalties for any violation of the provisions of the IT Act or by the certifying authorities or other entities related to electronic records and signatures, and the controller may also act as a mediator or arbitrator in disputes arising between parties concerning digital signature or electronic records. So that means it has arbitration, penalizing, record keeping, all these kinds of roles and powers. Now the Cyber Appellate Tribunal. Do we have a tribunal or all the work has to be done only by the controller and the CAs? No friends, we do have a tribunal known as the CAT Cyber Appellate Tribunal. It was established under the IT Act of 2000 to handle appeals against orders that are passed by the adjudicating officers. It functions to resolve the disputes related to the cyber laws. Who are the intermediaries? Intermediaries are the entities that facilitate online transactions or communications. This can be either a site or a service provider. These intermediaries have liabilities. They have certain legal obligations to prevent unlawful activities on their platforms. So be it any social site, website, or banking site, if there is something unlawful which is posted there, which is happening through them, then they are also liable as per the IT Act. Let's come to cyber crimes. Now, with this kind of knowledge, why do we need the controllers, the CAs, the intermediaries, the laws to protect them? Because there are a number of cyber crimes that we are all becoming privy to. Cybercrime refers to the criminal activity which is carried out using a computer or the internet. It includes a wide range of offenses such as hacking, phishing, online frauds, and many, many more like identity theft, bullying. Many of the cyber crimes are there. There are kinds of computer crimes. You can divide the cyber crimes between social crimes, computer crimes. Computer crimes use or involve activities like hacking, which is unauthorized access to computer systems, identity theft, like stealing personal information for fraudulent purposes, phishing, which is fraudulent attempts to obtain sensitive information, or even cyber stalking, like harassing or threatening individuals online, and many, many more. There cannot be an exhaustive list. You can keep and read about them. You can go ahead and find out more about cyber crimes. I can just give you basic information of some of the cases of cybercrime to have a better idea. Now, I'll take you through certain landmark judgments and cases. Just to refer some of them, there are famous cases like the Sony PSN hack of 2011. Here, over 77 million accounts were compromised. These accounts were hacked, and there is a case pertaining to this. I'll not tell you more. I will encourage you to go ahead, read about it, what the case story was, what the judgments were. Another important case which you should go ahead and find out, research and read about is the Yahoo data breach case of 2013, which is the largest data breach case which affected 3 billion accounts. If you want an Indian example, the Aadhaar data leak case, where sensitive information was exposed, sensitive information concerning millions of users was actually exposed, and this case also took a lot of media mileage. It is important for you as students of media ethics and laws to understand and know. Now, there are practical implications to the cyber laws in India and even worldwide. Indian cyber laws, particularly under the Information Technology Act, have been instrumental in addressing various cyber crimes and ensuring the legal regulations of the electronic transactions. I gave you certain cases, just naming them. Let us look at some of the notable Indian cases that highlight the significance of the Indian cybercrime laws. The famous one, which is the Shreya Singhal versus Union of India case of 2015. Now, this case is significant as it had a very major impact on how the cyber crimes are perceived and dealt with. This landmark case involved the constitutionality of Section 66A of the IT Act, which deals with punishment for sending offensive messages through communication services. Supreme Court struck down the Section 66A, holding that it was unconstitutional as it violates the right of freedom of speech and expression under Section 191A of the Indian Constitution. So if you say something online, you cannot be held responsible under 66A because you have the freedom of speech, whether verbal, written or online. This is what Supreme Court ruled out in 2015 in the Shreya Singhal versus Union of India case. The judgment emphasized the need to balance regulations in cyberspace with the fundamental rights, making a significant movement in the evolution of cyber crimes in India. So significant movement is marked here. Friends, when you talk of freedom of speech versus the rights that you hold online, so from bench to browser or from browser to bench, judgments have come out to give you more rights, to protect your rights and also to make you more responsible for this usage. The second case that I would discuss in this context is the Avinash Bajaj versus State case of 2008. Avinash Bajaj, the CEO of Bazi.com, which now became eBay India, was arrested after a user sold an obscene MMS video on this platform. This case highlighted the liability of the intermediaries. Now, Bazi.com or eBay is an intermediary under the IT Act. Although Bajaj was eventually discharged and the case led to a greater focus on intermediary liabilities and the responsibilities of the online platforms in India. This case underscored the importance of stringent cyber laws and the need for intermediaries to implement robust mechanisms to prevent illegal activities on their platforms. Therefore, whatever you sell on a e-commerce platform like Flipkart, eBay, Snapdeal, Amazon, or whatever you put out there is also the responsibility of that platform. They cannot say we do not know what the seller was selling. So this is a landmark case in this context. Another very interesting case is the SMC Pneumatics India Limited versus Jogesh Quatra case of 2001. The significance and the impact of this case are of utmost regard. This was one of the first cases of cyber defamation in India. An employee sent defamatory emails to his employer's associates to tarnish the company's image. The Delhi High Court granted an injunction to prevent the accused from sending any more defamatory emails. Now, can I send emails about you to someone and say, oh, this is my right to expression. Oh, I do not like you, so I can say something about you. Now, this amounts to defamation in the real world, but even in the virtual world, this case says that defamation is even virtual if it is done. This case sets a precedent for cyber defamation in India, highlighting that defamation laws apply equally in cyberspace and victims have legal recourse against online harassment and defamation. So there is anonymity, which is a big factor in cyberspace. Because people do not come out in open, they can just be anonymous or use some fake names or identities, and therefore they feel we have the right of saying anything to anyone. So trolling, defamation, even in the cyberspace, you are protected. This is what this 2001 judgment of the court ruled out. Now, State of Tamil Nadu versus Suhas Katti case of 2004. This was the first case in India where a conviction was secured under the IT Act of 2000. The accused was found guilty of posting obscene, defamatory and annoying messages about a woman in a Yahoo chat group. He was convicted under Sector 67 of the IT Act for publishing obscene material in electronic form. This case demonstrated the effectiveness of the IT Act in combating cybercrimes and also provided a strong message about the consequences of misusing the cyberspace. Friends, chat rooms or sometimes even the pages which are there on the social sites are considered to be private. information of those people who are interacting in there. And therefore, it becomes very, very difficult for people to come out and say, okay, this information was public. But this case highlighted it. It is one of the first cases in this regard, and therefore it is very significant. Another great case is the Tata Sons Limited versus Greenpeace International of 2011. In this case, Tata Sons filed a case against Greenpeace International for defamation and trademark infringement. Greenpeace had launched a game called Turtle vs. Tata, criticizing Tata's involvement in a port project. The High Court ruled in favor of Greenpeace, stating that it was a legitimate exercise of freedom of speech and expression. This case, friends, highlighted the complexities of balancing intellectual property rights and freedom of expression in cyberspace, and it underscored the role of cyber laws in adjuncting such conflicts. Now, is a copyright actually a right beyond any laws? No, it is not. So there is freedom of speech which can intervene with the copyright, and this judgment is significant in this regard. Let me take you through another important case which talks of phishing or data infringement. This is Pune City Bank call center fraud case of 2004. Employees of a call center in Pune fraudulently obtained and misused the credit card details of US customers, causing a major financial fraud. This case involved the unauthorized access of sensitive financial information and led to arrests and legal actions. This case illustrated the importance of cybersecurity measures in protecting sensitive information and the role of cyber laws in prosecuting financial frauds in the digital domain. So more and more such cases do keep coming in, and the judgments are also treated as landmarks where you can base further information about it. Arnesh Kumar versus State of Bihar is another interesting case of 2014. Though primarily related to the misuse of Section 498A of IPC, this case also involved the misuse of Section 66A of the IT Act. The Supreme Court issued guidelines to prevent unnecessary arrests and harassment by the police, emphasizing the need for proper legal procedures and the protection of individual rights. This case highlighted the need for checks and balances in the application of cyber laws to prevent abuse and to protect civil liberties. Now, these are some of the landmark cases which came out after 2000. IT Act got enacted, amendments are being made, but in law in India, there is something wonderful and very, very pro people, which says if your higher courts, the Supreme Court or the High Court has given a judgment, you can use this judgment to refer to and seek some provisions in the future cases that come in. Therefore, it becomes very important for you not only to understand the Act and its amendments, but also certain landmark cases in this context. Friends, I hope this was an interesting session on cyber laws. It is very, very important for you and me, even as citizens, to be aware of laws that protect us against cyber crimes, frauds, phishing, or other things. To summarize today's session, I would say cyber laws are essential for regulating cyberspace and protecting the users. The IT Act of 2000 forms the backbone of India's cyber law frameworks. Understanding cyber crimes and legal recourse is crucial for all of us in today's digital age, and court cases illustrate the evolving nature of Indian cyber laws and their significance in regulating activities in cyberspace, protecting individuals and organizations, and balancing various rights and responsibilities. With this, we come to an end of Unit 12, which is the unit on cyber laws of MJM025. As always, I would encourage you to go ahead, read the material provided by IGNOU, that is the study material in the print form, go through these videos, attend our counseling sessions which we do on television, through radio and even online, and do join the Google Classroom link which is provided to you. On the weekends, please go to your study centers, interact with your peer group and interact with your counselors. This overall would give you a very robust kind of a learning experience. Wishing you a great learning experience with IGNOU. Thank you so much for joining in today. All the best.